Hello, thanks for joining me. I see on Twitter and LinkedIn that there's been quite a few likes and shares on the fact that there's a major commentary on the Piney Rentals and F5 property case coming. I'm sorry if you have been misinformed, and the fact of the matter is that the major commentary is actually from me. So apologies if you think that someone important was going to be doing it. It's just me. However, I don't think any other lawyer is doing a video commentary about recent cases, and certainly not in the Northern Ireland jurisdiction, and definitely not in the private rented sector jurisdiction. So that being the case, we will plough on. I do apologise up front. This is possibly more of a documentary than a commentary. It is quite long, but there is quite a lot of information to get through, and I think if you're a letting agent, you will forgive me, because I think most of the information that I'm going to give you today is extremely relevant to your business. So without further ado, let's begin. This is a follow-on from my previous video about the recent court decision in Loughran against Piney Rentals Limited and F5 Property Limited, which deals with the fees that letting agents charge to prospective tenants. The judgment has far-reaching implications for the letting industry in Northern Ireland, and there seems to be little or no guidance for our letting agent colleagues. This therefore is my attempt to redress the balance to some tiny degree. Please note, none of this commentary constitutes legal advice. If you want that, instruct a solicitor who is an expert in the law of private tenancies in Northern Ireland. I should also say that I am not directly involved with this case. This commentary is based on information that is in the public domain and my own experience of drafting tenancy documentation, which has been used by thousands of tenants and thousands of properties over the past 10 years. If you want legal advice about this, retain my services. By way of introduction, the local press last week advised us that there was a landmark legal ruling which had closed a loophole for letting agents to levy extra charges on tenants. And the Housing Rights Service website is now suggesting, or submitting in their words, that the court decisions now means that there is a general rule in most instances that no fee can be levied by a letting agent on a tenant or prospective tenant in respect of the letting of a property. I'm not sure that's what the judgments actually said, but regardless of what the headline writers and the tenants' organisations are saying, there is little doubt that these two decisions may prove to be extremely significant for the private rented sector in general and letting agents in particular. As with many court decisions, this raises a lot of questions about where we go from here, and if you're a letting agent especially, you may immediately be faced with a barrage of emails from past tenants and prospective tenants, and you need to know how you're going to deal with them and what you're going to do with them. I'm going to look at these two cases in a bit of detail, because if you're an agent working through these issues, you'll need to understand what happened, which issues were raised, how they were dealt with, how they mirror or contrast with your processes and procedures, and you need to know how you're going to deal with them. Both cases are essentially about the same legal point, so what I'm going to say about the main issues are essentially applicable to both cases. So, the main issues then. The crux of these cases, as mentioned previously, is the hitherto unloved and neglected Commission on Disposal of Lands Northern Ireland Order 1986, which for the rest of this video and probably the rest of my life, I'm going to refer to as the 1986 Order. The article in question, article is in an order, so the article in question is Article 3, subsection 1, and I'm going to paraphrase it to reflect that this is a landlord and tenant situation, as opposed to a vendor and purchaser situation. So it says, where on the disposal of land, an agent acting for the landlord is entitled to be paid a commission, any stipulation made on the disposal to the effect that the tenant shall pay the whole or any part of the commission shall be void. Just like the famous sauce, which was named twice for being so nice, this article causes so much pain, we should probably have it again. Sorry. Where on the disposal of land, an agent acting for the landlord is entitled to be paid a commission, any stipulation made on the disposal to the effect that the tenant shall pay the whole or any part of the commission shall be void. So, there are three main hurdles which the tenant has to overcome before he or she can recover the fees that have been paid to the agent. We have disposal, we have a stipulation, and we have commission. So for the tenant here to win, he has to show that all of these three boxes have been ticked. First, both sides agreed that there was a disposal. The property in some way changed hands, so we don't need to worry about that. A tenancy agreement was granted, therefore there's a disposal. We now need to look separately at the two cases involving the two different letting agents to consider the stipulation part and the commission requirement, and that's what we're going to do now. So let's look at the Piney Rentals case first. Judgment on that was given in December 2017. Here, the tenancy agreement between the landlord and the tenant contained the clause which required the tenant to pay a one-off administration fee of £30 per tenant within 1 week of signing this agreement. Excuse me. Product placement. So, it's important to note that this fee was for a successful applicant who became a tenant, not an unsuccessful applicant who wasn't granted a tenancy. In fact, the court in both cases is very careful, as far as I can see, to make no statement whatsoever on prospective tenants who are not successful in their application for a tenancy and are charged a fee which is non-refundable. So, as I mentioned, we need disposal of the property, which we have. We need a stipulation of a fee as a condition of the tenancy. And we need the fact that the fee is really part of the commission that the landlord should be paying. We've already seen that the parties have agreed that there was a disposal, so we move on to a stipulation and the payment towards the commission, of course. The tenant said that he was advised that the payment of an administration fee was essential if he wanted to lease the property. The court agreed, therefore, that this was a stipulation to pay monies as part of the letting or disposal of the property. So at this stage in the proceedings, the tenant was arguably home on 2 out of the 3 points. The more difficult argument was on the commission element of the requirement. That is any part of the fee paid by the tenant actually part of the services that the letting agent was commissioned by the landlord to do? So we come to commission. Sorry that you're getting a law lecture now, but the 1986 order says that commission includes, that means it's not exhaustive, fees, charges, disbursements, expenses and remuneration. The tenant, of course, pointed to the use of the word fees in that list and therefore argued it was part of the commission. The court stated that the word includes in the definition clause suggested that the word commission was actually to be extended beyond its usual meaning, but it resisted the parties' invitations to look at how this was dealt with in other jurisdictions in GB and the Republic of Ireland. And to cut a very long story short, the court held that the definition of commission in this case was the remuneration paid to an agent for the work that they have been commissioned to do, and that is really important, and we'll come back to that throughout. That meant that the tenant should recover monies he has paid towards the remuneration of a letting agent for work that the letting agent has done for the landlord in letting the property. So in this case, did the tenant pay the letting agent for work that the letting agent had done for the landlord? In some ways, it's as simple as that. The letting agent argued that they had provided separate services to the tenant, and these were covered by the administration fee, which therefore wasn't part of the service that the landlord had commissioned the letting agent to carry out for them. I'm not going to get into the evidence, but this next bit is important. The learned judge collated the evidence and summarised the following services, which he said were services provided to the tenant by the letting agent in return for the administration fee, and frankly you should learn these off. Reviewing the tenant's application, checking the tenant's references, drafting the tenancy agreement, confirming that the standing order for the rent had been correctly set up, confirming that any guarantors were in place, negotiating any tenancy terms prior to completion, providing copies of the tenancy documentation to the tenant once it had been executed, and then there were 3 other services which I don't think are overly relevant here, but you can find them in the judgment. From these services, which made up the administration fee payable by the tenant to the letting agent, the tenant then suggested the following test. He said the court should ask itself, if the letting agent was not involved, would these services be performed by the tenant or by the landlord? The court essentially agreed with this test, there being no alternative test put forward by the other parties. And the court found that all of the services that I've just mentioned could be done only by the landlord if the letting agent was not involved, not by the tenant. So we turn to the Piney judgment. In the case against Piney Rentals, the court found that the tenant was indeed contributing in part to the cost of services that the letting agent had been commissioned by the landlord to do, and under the 1986 order the payment was void and the administration fee should be returned. So let's recap at this point. For the tenant's application fee to be void under the 1986 order, there has to be a stipulation to pay it for them to secure the tenancy. There has to be a lease, i.e. this only applies to applicants who actually become tenants, and they have to be paying for services that the landlord would themselves be doing if there was no letting agent on board. That was the thrust of what the judge found in Piney, and surprisingly, having essentially formulated the test, the court reapplied it in the later F5 Property Limited case in June, to where we now turn. The F5 case. Before we look at how that test was applied, it should be noted that the tenant also wanted the judge to make a declaration that all letting agent charges on tenants or prospective tenants would be in breach of the 1986 order and were therefore void. And we'll come back to that later. It's another important point. F5 Property Limited didn't defend the case as such, but the court still felt that it was up to the plaintiff to make their case to the court, and it was not, as the tenant had proposed, for the defendant letting agent to have to show that their fees were actually outside the remit of the 1986 order. This was a clear attempt by the tenant and their lawyers to reverse the burden of proof onto the defendant, which would really be very far from the norm in most court actions such as this. The facts of the case were broadly similar in that it was the same tenant who was again the successful applicant in an application for the lease of the property, this time with F5 Property Limited, who I'm going to call F5, as the agent. The services, however, supplied by the agent this time were different. But let's work our way through the test set down by the court. Was there a disposal? Yes, this applicant was successful, so there was a disposal when he became the tenant. The property was disposed of by way of a grant of a lease. Was there a stipulation? Well, yes, this was done orally and by a follow-up email from the agent, who said that the charge was made to, and I quote, successful applicants only. The commission element was then looked at. What service did the agent provide to the tenant? This is where the case was a bit different from the Piney one. F5 said that the fee was for an online application service and the ability electronically to sign the tenancy documentation via DocuSign. They argued, therefore, that this was really something which benefited the tenant and was not of direct benefit to the landlord, and therefore wasn't part of the service that the agent was commissioned by the landlord to provide to him or to carry out. The court applied the same test as before. If the letting agent was not involved, would the online service be provided by the landlord or by the tenant? Well, when you put it like that, it's not surprising to learn that the court felt that it was up to the tenant to decide how he wishes to receive applications, or indeed how he would direct that signatures be executed, and therefore he could have provided this service had the letting agent not been there to do so for him. Let's look now at the decision in the F5 property case. So we look now at the decision in the F5 property case. The court found, on the basis of its self-appointed test, that if no letting agent was involved, the services would have been provided by the landlord and not the tenant. Not a surprise there. That meant that in paying the administration fee, the tenant was contributing to the services that the letting agent had been commissioned by the landlord to do, and the payment was therefore void. Let's look at the declaration issue. On the declaration issue, finally, the court had this to say. Remember, the applicant wanted a declaration that any fees levied by a letting agent on a tenant or prospective tenant, which was a wider request than the facts of these two cases made out, were deemed to be commission under the 1986 order and therefore were void. The court didn't feel minded to exercise its discretion and make such a declaration. Its reason for doing so is not set out in depth in the judgment, but what the court did say is that over the course of these two cases, the court had made it abundantly clear the hurdles that a tenant will have to clear to make out a claim for reimbursement of an application fee which is found to be void under the 1986 order. The court also pointed out that, given the test that is formulated, it must have been clear to the tenant that the declaration, in the more sweeping and expansive terms that he'd set out requested, was not going to happen. It's my personal view, and this is only a personal view, that a number of other factors may have informed the judge's decision-making process, or must have at least have been apparent. First, the tenant was essentially asking the judge to reverse the burden of proof, making it for the defendant to prove innocence, as opposed to the more usual process where the plaintiff has to make their case. Secondly, I think the court wouldn't be seen to act in vain, lovely lawyer speak, and it must be apparent that with a fee ban in England on the horizon, our politicians, in the event that they ever do some work for the population that they're supposed to serve, will almost certainly follow suit of the English model, and in which case the courts will normally be slow to rule where legislation is likely to follow and carry out that anyway. Thirdly, the tenant wanted the declaration to cover prospective tenants as well, but that would have failed the disposal aspect of the test, because if the applicant is unsuccessful, then there is no disposal, there's no grant of a lease, and therefore under the 1986 order they haven't made out their test and they haven't cleared their hurdles. So, my personal thoughts on this. Where on earth does this actually leave us? There are a number of important things that we can take from this, And of course, if you're a letting agent, you will want to know first, what do you do with requests from past tenants for the return of application fees? And secondly, you'll want to know, can you charge tenants or prospective tenants in the future? Here's what has occurred to me in the past week or so. And I emphasise again, this is not legal advice, and I repeat that you should consult a residential landlord and tenant law expert if you are in any doubt. So in no particular order, here goes. First, this judgment refers only to tenants and past tenants, and not applicants who have paid application fees to letting agents and have ultimately been unsuccessful in being accepted for the tenancy. Those people are not caught by this judgment. That is obviously one of the reasons why the tenant in these cases wanted the declaration in those sweeping terms that we've discussed. It was put in terms which included unsuccessful applicants. The judgment, however, did not. My second observation is that the court did not say that all services that a letting agent could possibly provide to a tenant must be part of the service that the agent is commissioned to carry out by the landlord. And therefore, in theory at least, a letting agent can still contract with a tenant or prospective tenant to provide a service that is separate from their retainer with the landlord. I'm not entirely sure what the service might be, although I have an idea, more on that later, but the fact is that the possibility remains. As a helpful hint, the court has helpfully listed out those services which definitely are part of the services to the landlord, so don't offer these to the tenant and take a fee. There's no future in that for you. Thirdly, the court was invited by the tenant to accept the test that he proposed in terms of disposal and stipulation and commission. The court did so in the absence of any meaningful alternative put forward by anyone else. My question, and it's only a question, is simply this: is this the correct test? Is there a better one? Could the case even be appealed on this point? Could a later case possibly mandate a different test, for example, for prospective unsuccessful tenants? Fourthly, one thing about judge-made law, evidently, is that the judge can only rule on the cases and the facts in front of them. I don't feel that these cases were ideal ones for the court to decide on, or to put it another way, for the Housing Rights Service to back. With the Piney case, it isn't that common that the stipulation to pay the application fee appears in the actual tenancy agreement itself. And certainly looking at the thousands of times that my tenancy documentation has been used, we have never included that stipulation in a tenancy agreement. I just don't understand it. I don't see the point of it. That was always, in my opinion, going to be a problem for the defendant here. Fifthly, with the F5 case, they ultimately don't appear to have defended it, but I think that their situation, where they appeared to be offering something different and over and above the norm with the online application service, at least deserved some sort of a proper airing and a hearing, and I think ideally could have been debated in open court. At the end of the day, the tenant appears to have been backed by the Housing Rights Service, which obviously has a substantial budget, or a significant budget, whereas the letting agent had to choose between potentially ruinous legal fees in the small claims court, or repaying the £36 application fee plus a nominal small claims court application fee. It's just a pity, in my opinion, that F5's case didn't perhaps get the full airing that it deserved, because the service it purported to offer to the agent was, I think, over and above what other agents would be doing, and possibly would have been of more benefit to the tenant than the landlord. Sixth, it is clear to me that these two cases are only probably going to be the beginning. Notwithstanding that the judge has put the test in straightforward terms, the individual facts of these cases were, as I say, not overly common for the industry, and neither case deals with prospective tenants who have paid application fees and have ultimately been turned down. We may need to see other cases going through the courts before we can reach a final position on this. In fact, by the time this happens, we may have legislation in place to codify the position with complete clarity. So that's something to bear in mind. Seventh, if you're an agent, you need to know what to do right now with queries from past tenants and applicants. For unsuccessful applicants, these rulings simply do not apply to them, and if you get a query from them, they can be respectfully rejected. I don't see how they can bring themselves within this recent ruling, so that has to be good news. Additionally, for tenants and past tenants, you need to examine very carefully the services that you have provided for them and whether these services actually were part of the service that you were commissioned to do for your client landlord. I think it would be prudent, given the stakes, to obtain legal advice before you respond to any queries like this. But if you decide to crack on, then please make sure that your responses are short and to the point, rather unlike this video. In particular, if you're looking to reject a request for reimbursement, don't shoot yourself in the foot by admitting that you have provided a service to the tenant that the court has already said and specifically ruled is actually part of the service that you have offered to the landlord as part of your retainer. My ninth thought is, going forward, can a letting agent charge a tenant any form of application fees? Logically, given what we've just been talking about, the answer has to be yes, but it's a yes but. If you charge application fees to all of your prospective tenants and you accept one of them to be the actual tenant, then refund the fee to the one who actually signs the tenancy agreement and becomes the tenant. The unsuccessful applicants, I repeat, do not fall within this ruling and cannot seek recovery of their non-refundable application fees under this case law or the 1986 order. If you're that interested in the fee, get the landlord to pay it, or pay it yourself out of your fee, or just perhaps simply realise that on the basis of this court ruling, actually you shouldn't have been charging it to the tenant in the first place. My 10th observation is, here is the other option. Don't stipulate that the tenant pays an application fee or an administration fee. Perhaps you can give the tenant the option to get the homelet or the other acceptable tenant reference themselves and give it to you. They will pay for it directly and give it to you. Or you can offer to get it for them for whatever the fee is. The important thing there is that you're giving them the option. You're not stipulating. So, finally, going forward at the moment, before any future legislation is passed, and based on the recent court decision, which still may be appealed, or subject to any other case which further down the line clarifies the issues, your options are either to refund the successful applicant their fee once they sign the contract and become the tenant, or don't charge them at all, or offer them the tenant referencing service but emphasise that this isn't a stipulation and they can get the tenant reference themselves and pass it on to you. Is this practical? No. Is it legally and strategically safer? Yes, very much so. As I've said earlier, I expect that this is only the opening salvo in a much longer running battle. And as far as letting agents go and letting agents' fees go, I feel the writing is on the wall. When the Northern Ireland Assembly ultimately sits at some point, which I presume they will, I would expect that they will follow the English line and legislate to ban letting agent fees. Final word, you'll be delighted to know. You can't ignore the requests that you're going to get, or you possibly have got, from past and present tenants, but don't act in haste when you answer them. Think about what you're doing. Possibly take legal advice. Definitely take legal advice if you feel you should. But there you have it. I'm sorry that this video has been so long. If you're a letting agent, I hope you have got to the end of this. I hope it's of some use, and I wish you every success and every luck in the future in this brave new world. Thank you.